Okay, let's unpack this. As medical professionals, we're all operating under some pretty intense scrutiny.
Mm-hmm.
We're juggling our personal lives, families, and sometimes, you deal with the occasional legal hiccup, a parking ticket, maybe a minor issue with the local council.
Where it happens to everyone.
But when does that minor legal thing stop being personal and become a mandatory professional crisis? Where is that line drawn for reporting to the General Medical Council?
Right.
Because if you misunderstand these rules, it isn't just a small breach of guidance. It can put your entire registration, your whole career, in jeopardy.
And that's the critical tension we're diving into today.
Yeah.
This is all about the GMC's own guidance for reporting criminal and regulatory proceedings. And we're not just going to, recite the rules.
Yeah.
We're trying to extract the really high-stakes insights, the sources, all stress, clarity, promptness, and understanding the truly global scope of these duties. Our mission here is to distill exactly what the GMC requires you to report, and what that phrase, without delay, really means in practice.
So if we strip away all of the complexity for a moment, what's the one core takeaway we need to arm our listener with right now?
The core truth is this. The GMC requires immediate reporting for any serious legal involvement or formal admission of guilt. And that definition of formal admission is the real trap. This rule applies no matter where in the world it happens, purely because that compliance maintains transparency about your fitness to practice.
Okay, let's start with that absolutely critical element of timing then. Immediacy. The sources just repeat this mandate over and over. You must tell us without delay. From a practical standpoint, why is that speed so non-negotiable for the GMC?
Well, the immediacy is the standard itself. The GMC sees professional fitness to practice as an ongoing, continuous thing.
Right.
So if you delay reporting a serious charge or a finding for, let's say, 3 or 6 months, even if the eventual court outcome is minor.
The delay becomes the problem.
Exactly. The delay itself can become the primary issue of professional misconduct. You haven't just had a legal problem. You've failed in your professional duty to keep the regulator informed promptly.
Wow. That completely reframes the risk. It's the non-compliance, not the original offense, that might actually sink you.
It can be, yes.
And we have to reinforce the geographic scope here. This applies to all medical professionals. We're talking doctors, PAs, BAAs.
Everyone. And it applies anywhere in the world. That's a direct quote.
So if you're charged with an offense while practicing abroad, or even just on holiday abroad, the requirement is exactly the same.
It still stands. It's a universal professional duty. The guidance really outlines 4 main triggers from good medical practice that require this immediate reporting.
Okay, what are they?
So, first, being charged with a criminal offense. Second, being found guilty of a criminal offense. Third, and this is the tricky one, accepting a caution or an equivalent formal admission of guilt.
We'll come back to that one.
And fourth, being criticized by an official inquiry, which we'll definitely get into later.
And just to relieve a little bit of anxiety here for the listener, complying with this duty, it ensures transparency, but it doesn't automatically mean the GMC is going to take punitive action, does it?
No, exactly. Transparency is the mandate. Reporting just means you've done your professional duty. It does not automatically lower the threshold for them taking action. It just ensures they have the right information to make an informed decision and proves you understand your responsibilities.
Okay, so let's dive into the minefield. This is where the definitions the GMC uses are, I think, much broader than most people assume. We have to talk about these formal admissions.
Yeah.
Because these non-court findings are the things that most frequently catch busy doctors out. What exactly counts as formally admitting an offense, even if you never set foot in a courtroom?
This is probably the most crucial part for risk mitigation. The GMC really expands the definition of guilty. A formal admission is basically any mechanism where you formally acknowledge or accept accountability.
So a police caution?
That's the obvious one, yes. Accepting a caution, including the conditional caution. But it also extends to things that might seem more administrative, like accepting a community resolution order.
Okay, hang on. Can you simplify that for us? What is a community resolution order? And what about those specific financial penalties, like a fiscal fine in Scotland? Is that just a rapid admission of guilt?
That's exactly what it is. For a community resolution order, think of it as an out-of-court settlement. You admit guilt, often there's an apology or some reparation involved, and in return, you avoid formal charges.
I see.
And for the Scottish fiscal fine or discretionary disposal in Northern Ireland, yes. These are mechanisms where you accept a financial penalty offered by the prosecutor, and by doing so, you are formally admitting the offense without a full trial.
That covers a huge range of things that don't involve a court.
It does, and here's the key insight. The GMC is prioritizing reporting the behavior over the severity of the legal penalty. And there are two very specific low-level items that you absolutely must report because they touch on core issues of trust and conduct.
Hold on.
First, receiving a cannabis warning in England and Wales. And second, receiving an antisocial behavior order, an ASBO, regardless of whether that order came from civil or criminal proceedings.
That feels incredibly heavy-handed. A cannabis warning, an ASBO. These often carry minimal judicial penalty. Doesn't that risk becoming overly punitive, tracking really minor non-medical issues?
That's a fair question, and it gets to the why behind the guidance. These actions, so drug use, antisocial conduct, are seen by the GMC as directly challenging that core trust you need as a medical professional.
So the penalty doesn't matter as much as the behavior itself.
Precisely. The severity of the penalty is less relevant than the underlying behavioral pattern. If you show poor judgment in your personal life with illegal substances or public behavior, the GMC feels it needs to know to assess the potential impact on your professional practice.
Understood. Now, what about regulatory overlap? If another body restricts my practice, say a U.S. medical board or maybe a nursing council, does that also need immediate reporting here?
Absolutely. If another medical or professional regulatory body has restricted your registration, suspended you, or found you guilty of an offense because of fitness to practice procedures anywhere in the world, you must report it immediately. The GMC requires a complete global view of your professional standing. And that moves us on to that fourth major trigger official criticism. This is where the consequences can be huge, even without a criminal conviction.
Right.
Reporting is mandatory if you are criticized by an official inquiry or tribunal in the public domain, as long as that criticism relates to serious matters that could call your fitness to practice into question.
So this includes the big publicly funded inquiries, things like those under the Inquiries Act 2005. But the sources highlight a much more common event for clinicians, criticism from a coroner's inquest.
Yes, and this is where so many clinicians stumble. Coroner's inquests are common, and the line is quite nuanced. If the coroner specifically criticizes your performance, your competence, or your conduct in a way that suggests a serious failure. For example, a finding that your lack of action directly contributed to a death. You must report that. It's not just about being named, it's about the nature of the criticism being relevant to your fitness to practice.
What if the criticism is implied? Or maybe it's procedural, but doesn't formally assign blame to you? You know, if the coroner recommends changes to the hospital system based on your case, but doesn't mention you by name.
If the criticism is solely systemic or organizational and you weren't personally singled out by the coroner, then the individual reporting duty might not be triggered. However, and this is the important bit, if the judicial criticism relates to your specific failings in care, even if it's part of a broader finding, the duty remains.
So the rule is,
when in doubt about a coroner's finding, always treat it as high risk and seek immediate professional advice.
And that judicial criticism applies to civil proceedings too, right? If you're formally criticized in a civil lawsuit that relates to your fitness to practice.
Correct. Judicial criticism is criticism from a judge in either civil or criminal proceedings relating to matters that raise questions about your professional fitness. It's the formal public finding that matters.
Okay, and finally on this, let's look at the organizational link. The guidance says you have to report if your conduct directly contributed to an organization entering into a deferred prosecution agreement, a DPA. I think a lot of listeners won't even know what a DPA is.
A deferred prosecution agreement is a very serious agreement between a prosecutor, like the Serious Fraud Office, and a company. The company admits to serious economic crimes, things like fraud or bribery, and in return, criminal proceedings are halted as long as they meet certain conditions. It's a massive corporate accountability measure.
So the GMC is essentially saying that if you, maybe as a manager or senior clinician, were involved in conduct, say, fraudulent billing, corruption, that led to your organization facing this level of legal consequence, your personal duty is triggered.
Precisely. It links your individual professional conduct directly to the most serious organizational accountability. It just shows how far the GMC casts its net well beyond just clinical practice and into areas of financial probity and integrity.
Okay, this next section is just as vital as the mandatory reports because it helps reduce a lot of unnecessary stress and paperwork. Let's clearly define the three categories that do not require reporting. What can doctors skip?
Thankfully, the guidance is mercifully specific here. First, You don't need to report standard penalty notices for disorder, unless it's that upper tier penalty level for certain serious offenses.
Okay.
Second, and this is the most common one, you don't have to report payment of fixed penalty notices for routine road traffic offenses. So speeding fines, parking fines, things like that.
So if I get caught speeding and I just pay the fixed fine, that's definitively outside the reporting radar.
Absolutely. And third, payment of fixed penalty notices issued by local authorities for minor issues.
Right.
We're talking about dog fouling, littering, noise complaints, things outside of criminal proceedings that relate to professional conduct.
That's a huge relief. Let's use that helpful analogy you mentioned before to just draw the final line here.
Sure. Think of the line separating mandatory reporting as a professional radar screen. Fixed traffic tickets and minor local authority fines are completely outside the radius.
They don't light up the screen.
They don't light up the screen. However, anything involving a formal admission of guilt, accepting a caution, getting a warning for illegal substances, official, judicial, or inquest criticism, that immediately throws up a big red flag. The key distinction is that formal admission of guilt or the serious relevance to your competence.
Given how gray some of these scenarios can be, especially around the nuance of a coroner's criticism, what is the safest action if you are genuinely uncertain about whether a situation meets the threshold?
The mandate is crystal clear. Seek advice immediately. The guidance explicitly encourages you to contact a defense body, a medical association, or even the GMC itself if you're uncertain. That is the only safe action. It's much better to seek clarity than to face non-compliance because you delayed reporting.
Proactive defense is your best tool.
Absolutely.
This has been an incredibly high-yield deep dive into professional accountability. Let's summarize the 3 absolute essential takeaways that every listener needs to remember.
Okay. First, the reporting duty is global. It applies anywhere in the world, and it must be done without delay. That's for charges, guilt findings, or any formal admission of guilt, like a caution or a cannabis warning. Remember, the GMC is looking at the behavior, not just how severe the penalty was.
Right. Second, specific low-level offenses like fixed road traffic penalties or local authority fines for noise or littering do not need to be reported, and that relieves a huge administrative burden.
And third, if you face criticism from any official inquiry, and that includes a coroner's inquest, or if you are ever unsure about a complex scenario, the safest immediate action is always to seek expert advice from your defense body. Don't try to adjudicate the rule yourself if the situation feels at all ambiguous.
The ultimate goal of this guidance is really to empower you to use your professional judgment effectively and, well, proactively defend your livelihood. By understanding these specific boundaries, you maintain trust and you protect your ability to practice.
Knowledge really is your shield in the professional world. Stay well informed, and just remember that being proactive about compliance is the only way to safeguard your future.
That was a deep dive into the GMC's mandatory reporting requirements. We appreciate you trusting us to keep you well informed.